Parliament has banned hiding compulsory fees until the final checkout screen. Charging those fees stays perfectly legal, and the ban does not start for another year. 4 years of consultation ended in the first week of July 2026, when the Competition and Consumer Amendment Unfair Trading Practices Bill passed both houses. Treasury describes it as one of the most significant strengthenings of the Australian consumer law, the national rulebook governing how things can be sold to you since that law was written. It does 3 separate jobs. It creates a general ban on unfair trading practices. It sets new rules for subscription contracts. It tightens the rules on hidden fees. Manipulation is the word the legislation actually uses. A business breaches the general ban if it manipulates a consumer or unreasonably distorts the environment in which that consumer makes a decision, and that conduct causes or is likely to cause detriment, financial or otherwise. Dark patterns sit squarely inside it. Interface design that steers you into a choice you did not intend, like a grayed out decline button or a countdown timer that resets when you reload the page. The protection covers individuals. It does not, for now, cover you when you are buying as a business. Drip pricing is the part you have felt most often. A price is advertised, you commit, and then service fees, handling fees, and processing fees surface one screen at a time until the total is nothing like the number that got you in the door. From commencement, a business displaying a price has to tell you at that moment whether a transaction-based charge applies, meaning a compulsory fee that is not payment for the thing itself, but falls due at the same time, and whether the price on screen already includes it. Subscription rules point the other way, at the exit rather than the entrance. Where you signed up online, or the business offers online sign-up at all, every method of ending the contract has to be easy to find, straightforward, and free of steps that are not reasonably necessary. The 2-minute sign-up and the 40-minute phone queue to leave are on borrowed time. Borrowed time is not the same as gone, though, because most of the detail is not in the act. It arrives later, in regulations nobody has written yet. Someone books 4 cinema tickets advertised at $22 each. $88 they assume. At the final screen, a $1.80 booking fee per ticket appears, and the card is charged $95.20. From the 1st of July 2027, that $7.20 has to be visible at the top of the process instead of the bottom. The amount they pay is still $95.20. Nothing in the new law caps a fee, removes a fee, or makes a fee refundable. This is a disclosure reform. Hidden compulsory fees become unlawful. Disclosed compulsory fees are compliant. A business that moves its booking fee from the last screen to the first has met the standard in full, and its revenue has not moved a cent. Penalties are the reason the reform has teeth at all. A corporation faces up to the greater of $100 million, 3 times the benefit obtained, or 30% of adjusted turnover over the breach period. That 100 million figure is itself new, doubled from 50 million by separate legislation that commenced in March 2026. Individuals face up to $2.5 million. Dendy Cinema paid a $19,800 penalty in June 2025 after the ACCC issued an infringement notice alleging it failed to prominently display the total ticket price, including an unavoidable per-ticket booking fee at the earliest opportunity in the booking process. Paying an infringement notice is not an admission of liability. That matter ran entirely under the law as it already stood. The single price obligation the regulator relied on has been in the Australian consumer law for years, and the new section sits on top of it rather than replacing it. 12 months is the number worth holding on to. Government gave business a full year of runway before the rules bite, and funded the regulator to publish guidance across that year so companies can prepare. Consumers were given the same 12 months of the practices the law has just declared unfair. The quiet part sits in the boundaries. The general ban protects individuals who are not carrying on a business. Whether it extends to small businesses and franchisees was still out for consultation, with submissions closing in July 2026. Financial services sit outside it as well, with Treasury saying it is working with the states, territories, and ASIC to explore alignment there. So a countdown timer on a retail checkout is captured. The same design pattern inside a banking or insurance app is a separate conversation that is not finished. Between now and the 1st of July 2027, the practices in question remain lawful, and enforcement runs on the older provisions. Those provisions are not nothing. Misleading or deceptive conduct, false or misleading representations, and the single price rule have all been used against hidden fees, and the Dendy matter is one of several the regulator has run on exactly that basis. Existing subscriptions are the other gap worth naming. The subscription provisions apply to contracts entered into from commencement and can reach older contracts that are renewed, varied, or extended after that date. A contract signed today that simply rolls over on unchanged terms is not clearly captured by any of it until something about it changes. Step away from your own checkout for a moment, because the design question underneath this is bigger than any single fee. What follows is opinion rather than law. Publishing the regulations early would cost the government very little and change the outcome a great deal. The Act deliberately leaves the specifics to rules that do not yet exist. What a subscription reminder must say, when it must be sent, which contracts are excluded. That means the 12-month runway businesses were handed does not really start until those rules land, and a review is already legislated for 2 years after commencement. Writing the detail in the first 6 months, rather than the last, would give that review something real to measure instead of a scramble. Which fee has annoyed you most? The booking fee, the service fee, the processing fee, or the one whose purpose you still cannot work out? Tell me in the comments, because that answer is the genuinely interesting part of this story. If there is another system you want pulled apart, name it, and the most requested one gets made next.